Good afternoon, everyone. Thank you guys for coming. I apologize, Alderman Garza won't be able to make it today. She sends her best. I'm Maria Lazzaroni from her office. We're going to get a lot of great information from the Cook County Clerk's office. And I'm going to hand it over to Robin Stagers. She is with the Cook County Clerk's office.
First of all, let me thank all of you here. Thank you for coming out tonight. This afternoon. I got my days and nights mixed up. Thank you for coming. We appreciate you coming. We have people here in person. Why do we have this echo? And we have people online. So our online Zoom audience, we have our attorney Kane Trent on there to do the Q&A. And we have here Scott Kozlov, one of our attorneys from the Cook County Clerk's office. And we have our two community partners, Kathleen Duhigg and Theodore London. So what I'm going to do first, well, that's what I should have done first, was to do housekeeping. Everybody got forms when they came in. Everybody signed in. Everybody got index cards. Okay. So with the index cards, we want you to jot down any questions that you may have during the presentation, okay? Because that helps us to go through the presentation flawlessly. After the presentation, we're going to turn it over for Q&A to our attorneys to answer your legal questions. We cannot answer as staff your legal questions, okay? So I want to make sure that you understand that. Cook County Clerk, we're here on behalf of Karen A. Yarbrough, who is your Cook County Clerk. She is the one that is very passionate about this program, bringing this information to you so that you're educated about options that you may have with regard to your estate planning and protecting your property. So I have staff here with me, Lindsay Chase and Brian Cross, who stepped out, and I want you guys to take notes because it's a lot of information. You have particular questions that you may have that you can address to the attorney, and we're going to move on forward. Clerk Yarbrough apologizes for not being able to be here, but you will still get pertinent information that you need, okay? You have any questions for me at this time? No? We have a translator over here. If you don't speak English, Dan Gonzalez has joined us, so if you have questions that you need interpreted, Dan Gonzalez will be here to help us. All right? Let's go with the presentation.
Hello and welcome. I'm Karen Yarbrough, your Cook County Clerk. Thank you for joining me and us for this presentation on property fraud and managing your property after death. The Cook County Clerk's Office is one of the largest consolidated clerk's offices in the entire nation. In addition to functioning as the chief election authority for suburban Cook County, the clerk's office maintains birth, marriage, and death records. Our office also assists property owners in redeeming delinquent taxes and serves as the clerk to the Cook County Board of Commissioners. The clerk's office also has a recording operations division, which records, stores, and maintains land records and other official documents, including deeds, transfer on death instruments, as well as tax and real estate documents. Now, nobody wants to talk about death or end-of-life planning. But when you fail to plan, you plan to fail. And we all need to be aware of the threat of property fraud and how we can guard against this type of financial crime. At the Cook County Clerk's Office, we are here to serve. And we hope that this information you receive today will be helpful on these important issues that impact all of our daily lives. Now, let me introduce you to my trusty assistant who will guide us through this presentation.
Thank you, Madam Clerk. Before we begin our discussion, we want to let you know that we will have volunteer attorneys available at the end of the presentation who can answer your questions about the topics we will be covering. If you are joining our program via Zoom and have questions that come up during the presentation, simply type your question in the Q&A section through your Zoom link and the attorneys will respond accordingly. Now, let's begin our discussion by talking about property fraud, which can also be known as deed fraud. So, what exactly is property fraud? Property fraud is the fraudulent and illegal recording of a document against your home's property records. We call it paper terrorism, and it's a very real problem and potential risk for all property owners. How can this happen? Almost every state has an open and public recording system, meaning that you cannot freeze your chain of title like you can your credit report. Plus, county recorders are not authorized by law to validate legal claims made in documents. Property fraud can involve the recording or filing of false or forged transfers of ownership, quitclaim deeds, or the filing of a bogus lien to steal property or harass an unsuspecting property owner. Even if your home is paid off, that does not stop someone from filing a new deed on top of it without the property owner's knowledge. Let's look at this NBC5 investigative report that takes a close look at how property fraud can occur.
By law, it is a line anyone can stand in and a fee anyone can pay. $40 is all it takes to get a deed or other document officially recorded in Cook County. A simple perk of open government openly abused by serious scammers.
I think they call them, financial parasites.
She was new to her office as recorder of deeds when Karen Yarborough says she first spotted the trouble.
To steal a home, all you have to do is doctor some paperwork up and Photoshop it, bring it to the recorder's office, record it, voila, you own a home.
Con artists exploiting a system that relies on the honesty of those who use it, recording forged documents in order to steal a home outright. Sound far-fetched?
This is a kind of crime that I never imagined that could happen.
It did to Chicago Treasurer Stephanie Neely until it happened to her.
I get this call, I'm like, what do you mean someone has changed the name on my deed? What do you mean? How did they do that?
In her case, a stranger recorded a fraudulent deed, waited until she was at work, and then changed the lock.
They want to physically be in your house, because once they're there, it's very difficult to get them out.
Precisely what happened to this Chicago woman.
This individual had paperwork that was Xerox that showed the deed was in his name.
She asked us to conceal her identity because
You're in constant fear that they will try something next, because believe it or not, they did come back 3 days later.
one man connected to her case was arrested and convicted. As the recorder's office continued to field fake documents,
I decided that I couldn't sit idly by and watch this happen.
Yarborough brought in this man,
They believe that the government created artificial duplicates of all of us.
an expert on sovereign citizens, the extreme anti-government movement often behind this crime.
They believe they can completely ignore our government and do whatever they want to do with impunity.
Pitcavage calls it paper terrorism and teaches the red flags, like the punctuation sovereigns add in the middle of names, the refusal to use mainstream addresses or zip codes, and how they employ lengthy, arcane terms. The flurry of documents they file may be fake, but their threat is real.
They're bullies. They're brazen. They think that nothing can touch them.
A lot of times they'll come in and overwhelm our frontline staff. It may be 20 of them will come in.
Yarborough has a catchy comparison she uses to get a non-believer's attention. In Illinois, it is easier to steal a home than it is to steal a car.
It's fraud and, they're taking people's homes.
So there is now a simple way for some homeowners to protect themselves, the free property fraud alert system. You load your property index number, then you get an alert if any document is recorded in connection with your property. Counties across the country are now turning to this kind of system as these cases of mortgage and property fraud continue to grow. Lisa Parker, NBC5, investigates.
To combat this problem, Clerk Yarborough created a property fraud unit with investigators and caseworkers who respond to and investigate any complaints of property fraud. The clerk's office also offers a free property fraud alert that will provide a telephone call or email to the property owner anytime a document is recorded against their property or the property of a loved one. There are 3 easy ways to sign up for the clerk's free property fraud alert. You may sign up in person at the clerk's office, you can sign up online, or you can sign up with a telephone call. Once registered, if you receive an alert or have a reason to be concerned about property fraud, you can contact the clerk's property fraud unit and our staff can help research the problem and coordinate a response. Call 312-603-4000 or visit our website at cookcountyclerk.com/property fraud. On a related note, while we're on the topic of your chain of title and fraud, property owners often need to obtain an official copy of their property deed when purchasing a home or for tax purposes. You should be aware there is a predatory practice aimed at homeowners in which companies offer a copy of your property's deed at a large markup price, sometimes exceeding $200. The clerk's office wants to remind you that we offer the same service on our website starting at just $5. In-person prices can range from $10 to $55 depending on the format and age of the document. So either way, there's no reason to pay exorbitant prices to gain access to these essential documents. Now, let's move on to the second part of our program, which is making plans to manage your property and assets in the event of your death. As Clerk Yarbrough noted, no one wants to talk about death or end-of-life planning, but it's critical to manage your assets to protect your family and loved ones. Having a sound end-of-life plan is one of the greatest gifts that you can provide to your children and family members. Consider this. What do you think these 3 legendary individuals have in common? Prince, Aretha Franklin,
87 years ago, our fathers,
and Abraham Lincoln. Actually, they have something very unfortunate in common. They failed to make plans for their assets upon their death. No will, no trust, and no plan. Now, let's consider someone who thought he had it right. Music legend James Brown, the godfather of soul. When he passed away in 2006, Brown's estate was worth an estimated $90 million. When he died, Brown left behind a plan for most of his estate to pay for scholarships for children in need in South Carolina, the state where he was born. But that will was challenged by family members after his death, resulting in more than 12 lawsuits. It took more than a decade of litigation before Mr. Brown's assets were designated as he had intended. So how do you get it right when it comes to your property after death? The best advice is to consult an attorney or estate planning professional to provide you with advice for your specific circumstances. But you should also know that under Illinois law, you can transfer your home, your car, or your bank account to a loved one without a will or a trust, and without having to pay any fees or court costs. Here are the details on how to transfer your property. First, a transfer on death instrument. The clerk's office has a free document on our website known as a transfer on death instrument. We call it a toady. No, not that kind of toady. You can also obtain this document at no cost from any attorney or legal aid organization. The form should be completed and notarized and then recorded at the clerk's office in our recording operations division. The transfer on death instrument will then be recorded on your property's chain of title, and, upon your death, the person designated to receive your property can do so after completing the required forms. Please note that the clerk's office cannot assist you in the preparation of a transfer on death instrument or any legal document. We do not provide legal advice to customers. Next, let's discuss a payable on death instrument. You can transfer the funds from your local bank account in a similar way. Utilizing a tool known as payable on death instrument, a person can transfer assets in a bank account to the beneficiary of their choosing after death. A payable on death instrument can be obtained and used at most financial institutions, for checking and savings accounts, as well as certificates of deposits, CDs, money markets, and savings bonds. Even if you have completed a payable on death instrument, the account holder has full control of their funds in the account until the time of their death. When the account holder passes, the beneficiary can claim specified assets directly from the financial institution without having to wait for probate court proceedings. Finally, let's discuss a beneficiary affidavit. There is also a mechanism to transfer your car to a designated beneficiary. A vehicle owner may change, add, or remove a beneficiary on the title of their car by completing a free beneficiary affidavit through the Illinois Secretary of State's office. To obtain this beneficiary affidavit, go to the Illinois Secretary of State website at www.ilsos.gov. Keep in mind that if money is still owed on your home or vehicle at the time of your death, your beneficiary will be responsible for the mortgage and payments moving forward. On behalf of Clerk Karen Yarborough, we hope that you have found this presentation useful. The clerk's office is your first line of defense against property fraud, so we hope that you will take this opportunity to sign up for our free property fraud alert if you have not already done so. Managing your property and your assets in the event of your death is also critical to protecting your family and your assets, and to ensure that your wishes are carried out after your death. A copy of this presentation is available on the clerk's website if you would like to review it again or share with a friend or family member. Please visit www.cookcountyclerk.com/PAD resources to review the presentation. For more information on how to host a Property After Death Property Fraud Forum in your community, contact our Special Assistant to the Clerk for Community Affairs, Robin Staggers, at 312-603-3974 or email robin.staggers@cookcountyil.gov. Now let's ask the volunteer attorneys who are joining us to introduce themselves, and we will open up our presentation for your questions.
Great. I'm attorney Kathleen Farrell-Duhigg. Thanks for coming out today. We're going to answer some questions that you've submitted. Some of these questions may be more appropriate for someone from the clerk's office here. One question here is, how does a will differ from forms mentioned? Okay, so the will disposes of your personal property after your passing. And if you have only a will alone, it will have all of your items distributed per your instructions. Okay, so anything that you own. So it could include real property, it could include all of your personal things like that. A will alone does not help your family members to avoid probate, or your loved ones, or whoever you want to leave things to. It helps to express your wishes upon your passing as to how you want your estate distributed, but it does not help you to avoid probate and the costs that Ted was talking about, the attorney fees, the lengthy amount of time that you have to go to court. And by probate, I mean appearing in court, opening up a probate estate, which could take a very minimum, you're talking about half of a year, but it could be a years-long process. Okay, so the will does not help you to avoid probate. A living trust, on the other hand, that was a question here, does help you avoid probate in most instances. So a living trust is a document that you create. You're the original trustee of your trust. It allows you to be able to put your assets into the trust, including your property. Your property should be deeded into the trust. And it allows you to have more of a benefit than just avoiding probate. It additionally allows you to have a protection in case something happens to you where you become incapacitated in your lifetime. It allows your successor trustee to be able to step in and act using your assets for your benefit. And so in most instances, a living trust would be recommended for at least an unmarried person, as most things are not held in joint tenancy if you're a single person. If you're a married person and things are held in joint tenancy, simple wills may be sufficient, but you should have other documents in place, like a transfer on death instrument if your property isn't in joint tenancy. I'm going on because it's a big, it's a broad range of discussion here, but that's just a broad overview for you. Okay. You want?
Yep. So let's say forms acceptable, mail in any support and home ownership with disabilities. Form acceptable, mail in. That may be better for.
And we can just address any support for owners with disabilities. I'm not sure if that question is related to the transfer on death instruments specifically, or to an estate plan.
You know what? May I say something as well about wills? You know what? I haven't done a will for my clients in over 20 years. Because the bottom line is, with a will, your family's going to have to go through the expensive, time-consuming, stressful probate process. A will does not keep your things out of probate court. And I know even smart, accomplished, hardworking people that have accumulated quite a bit of real estate and financial assets, many of you still believe that a will keep your things out of probate court. By a show of hands, how many of you think that a will keep your things out of probate court? Yes, at least one lady is honest enough to say she believed it. But I know many of you believe that if you have a will, it will keep your things out of probate process. And it's exactly the opposite. You're going to have to pay filing fees, lawyer fees, get a bond potentially, and a number of other fees. And it's going to be at least 6 to 18 months or longer if your family start fighting it. So when I speak, and when I speak to audiences, one of the first things I advise them against is a will. If you have a will, your loved ones are going to have to go through the probate process. Remember, for most people, there are really only 3 primary things that you want to keep out of probate court. Primarily, the home, any other real estate, yourselves, and the money. That's it. No one's fighting over the refrigerator. They're not fighting over the old Fox stove. Let them. Well, you can't stop a fool from being a fool. So there's nothing you can do about that. They'll fight over gum. But what would send them through the court would be the home, the ability to make decisions for you if they needed to, and the money. So those are the 3 things that you want to keep out of probate court. So just quickly, here's how you do it. Generally, the real estate should be in some sort of trust for sure, living trust or a land trust. Now, you can use a toady. Normally, I only recommend a toady for my clients for one of 2 reasons. One, if there's very little equity in the home, or if there's a reverse mortgage. If there's, because that's a less expensive way to transfer your home. But some of you need something a little bit more sophisticated than just a toady. But a toady will keep your home out of the probate process, but there are other things that offer a couple of other benefits that are really beneficial. So all real estate should be in some sort of trust. Additionally, you all need power of attorneys for yourselves. There's 2 kinds of power of attorneys, one for healthcare, one for business matters. You all need them both. Especially, whenever we do these things, there's always more ladies than men. And so we should probably give the men a hand for being here. Let's give the men a hand. Because we know they don't even like to mow the lawn, let alone come to something like this. But it's important for you ladies because you ladies are caregivers. And you ladies, respectfully, normally outlive your husbands. So you want to make sure that you're in a position to make decisions for your spouses, and someone can make decisions for you, because just because you're married does not give you the right to make decisions for your spouses. So everyone needs power of attorneys here too. One for healthcare, one for business matters. And if you have those, you're not going to have to go through the guardianship process to be in a position to make decisions for a loved one, even if it's a spouse. And then third thing is the money. Just like we heard on the film, if you have current beneficiaries on all of your accounts, well, when you go to heaven, your loved ones will get your money very easily without going through the expensive, time-consuming, stressful probate process. Just 3 things: the real estate, yourselves, and the money. If you keep those things out of probate court, you're going to be doing a good job.
Okay, we've got a lot of questions here. Yes. So, can you leave your house to more than one person? Yes. That was an easy one.
Yes, okay. Must husband and wife each fill out a form that are discussed today. So presumably you're talking about toady forms. If both names are on the deed, anytime there's more than one name on the deed, to make any sort of transfer, all parties whose names are on the deed must sign the documents.
If one already has a will, how is that canceled? And this is a two-part question. So does a living trust cancel that? So whenever we prepare a living trust in our office, we also prepare what's called a pour-over will. That catches any assets that you forgot or failed to put into the trust. It doesn't help you avoid probate, but it allows things to pass through the trust. And wills are revocable, and they don't get filed until after death, and so you can change it any number of times during your lifetime. The testator, the person who creates the will, should destroy the will if they want to revoke it.
Got it. Here's a question. Is a revocable living trust for your home the same as a toady instrument? The answer is no. They are two completely separate documents. The toady will, in fact, keep your home out of probate court, and so will a living trust. The difference is with a living trust, you can have a little bit more specificity in how the property is managed. For example, you can say, I want the property sold, I want the money divided between all the kids or just the good ones. That's up to you. But with a toady, you cannot have that specificity. You can just name who's going to get it after you with no particular specificity. Here's another reason for a living trust versus a toady. With a living trust, you can leave provisions for a special needs loved one or an aging parent that you could not do in a toady. So again, I normally recommend some sort of trust for my clients rather than a toady because they just offer an additional level of benefits that most of you are probably going to need.
And another benefit of the living trust is if you are leaving, if there's a possibility that some of your assets will go to a minor, say a minor grandchild or something of that sort, you can put provisions in there for that child or grandchild to not get access to those assets until they reach certain ages. I mean, you can designate later ages in their 20s, and the trustee can hold on to that for their benefit and to be able to use for medical expenses until they reach that age when they can just get the assets outright. And I believe there's a question here, what's the difference between a will and a trust? I believe we already addressed that. I would recommend one, yes, because
Yes.
I've seen people come in with documents that they've gotten from online or things like that. Oh, the worst is if you see one come in with social security numbers on it. So you can't rely on the internet to be able to give you everything that's going to meet the requirements by that have been provided by legislators in the statute. So in order to make sure that that will is going to be valid and the trust is going to be valid, it should be prepared by an attorney.
And here's another reason why. Because if you prepare a document on your own and it's not properly prepared, when you need it most, it's going to be void. And then that's going to cost you what? Money. So you're going to do better paying a lawyer up front, have them do it properly, rather than doing it on your own and then paying 2 or 3 times the cost on the back end because you did it improperly.
Yes, definitely. Okay, the difference between a will and a trust. A will does not allow you to avoid probate. It just says how you want your assets to be distributed upon your death. A trust, however, as long as you put your assets into the trust, changing the name of your assets, deeding your property into the trust, what we call funding the trust, as long as you put those assets into the trust, then that will allow your family to avoid probate. And by probate, we mean going to court 6 months to years, thousands of dollars in attorney fees and court costs. Plus, the additional benefit of the living trust is that it allows you to have continuing care, to have your successor trustee take over if you become incapacitated, and to be able to use your assets for your benefit during your lifetime. And then it just allows for your loved ones, whoever you leave your estate to to have a much easier time distributing your estate after you're gone.
You know, if I may add one other thing, a living trust also allows you to control from heaven, because you get to outline how you want the money distributed to your loved ones. It can be incrementally. Any condition that you want them to meet to entitle them to the money, you can put it in the trust. For example, you can say when you turn a certain age, when you graduate from college, when you divorce the person I never liked in the first place, you'll get the money. And so you cannot do that in a will. With a will, you can just outline who's going to get it, but you can't have the specificity of what they do when what once they get it. Again, I don't do wills for my clients because if you have a will, you have to go through the what process? Probate. And that's typically what we're trying to help our clients avoid.
Okay, if you have a family member on a checking account, is it necessary to have other forms? Yes. So here's one. Sometimes people try to do something with just a simple will, a cost-saving measure. If I put people on all of my accounts, if I have a will, if I do a transfer on death instrument, it's kind of the backdoor way to avoid probate. I don't recommend that at all. If you have someone else on your checking account, they are a joint tenant. And so that money is equally theirs as it is yours. And so oftentimes people will, what we've seen happen is people come in and they're, say, on an account with their parent who's passed. Technically, that money is theirs. It is not part of the estate. And so whatever the parents' wishes were with respect to that money, they do not have to honor that. They don't have to divide it equally among the siblings because it's, by default, technically it's theirs.
Attorney Kathleen is so polite. Let me just make it a little more plain for you. Never, ever, ever put your children's names on your accounts and on your real estate. Because if you do, they can access the money while you're living. I've seen children and grandchildren take hundreds of thousands of dollars out of their parents' and grandparents' accounts. And then if you put them on your home while you're living, they own it now. And you know what happens? If they are sued, where can they collect from? Your home that you've added their name onto. So we never want their names on your accounts. We never want their names on your real estate. We want them to get it very easily after you, not while you're living. So please don't add your children's names to your accounts, nor them to your real estate. If you come to my office and even ask me to add your child's name to your home, or even ask me to even transfer it to them, you're going to have to go to another law office. I am just not going to do it. So please don't do that. Most of my clients, even the ones well into their 90s, because people are living longer, happier, healthier lives, no matter how old they are, they still want to control their own stuff. When you add their names to it, you're losing at least half of the control.
So we have some questions. We still have a lot of questions to get to. We have questions in the chat. Does a living trust work with a special needs trust for a child with lifelong disabilities? So what we, at our office, at Farrell & Farrell, we prepare what's called a supplemental needs trust, special needs trust. And what you should have is a trust and this supplemental needs trust in addition to that. And that designates that whatever share you want to go to that child with special needs, with disability, that never becomes the child's property, okay? Because we don't want it to interfere with the benefits that they're receiving, Social Security, disability, things like that. So it allows you to be able to supplement their life with maybe automobile for their transport and things like that that go beyond. But that money never becomes property of that disabled child.
Great question. Here's another question. If your will states that all property must be sold, will that hold up? That's one question. The answer is yes. If you have a will that says the property must be sold, that will hold up in court, but you're going to have to go through the probate process, a lot of fees, a lot of lawyer fees. Lawyers are grateful for that. Thank you. But there is a way to avoid it. Okay? So if I wanted a property of mine to be sold once I pass away, I would not be passing it along through the will. I would want a living trust where you're going to name someone that's going to manage the whole process after you, called a successor trustee, and then you're going to advise them to sell it, and then you're going to advise them how you want the money divided. They'll be able to do it very seamlessly once you pass away. They're not going to need to come to one of us, pay thousands of dollars. Lawyers aren't inexpensive. And so you can avoid the whole process. So yes, a will, to answer the question, yes, it will be held up that a property will be sold if you have it in a will, but it's going to have to go through the probate process. And it says if you have an administrator also noted in the will, will it stand? Well, yes, if you have someone named in the will that's going to be the executor of the estate, yes, that will be valid. But again, all along, filing fees, lawyer fees, notice fees, posting fees, fees. And then here's what lawyers love the most. I'm sorry, Attorney Kathleen, to tell these secrets. When your families start fighting, we love that the most. You know why? We're billing you more. So now you have 2 or 3 lawyers on this same estate, and by the time you go to heaven, I'm just telling you the truth. By the time you go to heaven, then the estate's been evaporated because of fees. All can be easily avoidable.
There were some questions in the chat asking the attorneys again to introduce ourselves. Again, I'm Kathleen Farrell-Duhigg with the law offices of Farrell & Farrell.
Hi, I'm Attorney Ted London, offices at 1718 East 87th Street, Chicago.
And my name is Scott Kozlov. I'm the Chief Ethics Officer and Legal Counsel for the Cook County Clerk's Office. Before you go on, there were a couple questions as to process, and I want to try and address those for you. There was a presentation as to property fraud alerts and a program that the clerk has on property fraud alerts to alert you when something is recorded against your property. You can sign up for that program either in person by walking into our office at 118 North Clark, or you can do it by phone by calling our office and having somebody register you, or you could also do it online. So if you go to the clerk's website at www.cookcountyclerk.com, you can sign up for the Property Fraud Alert program. The question that I received on the program was, does the program prevent property fraud from occurring on the chain of title to your property? And no, it does not. There is no system. The law has not established a program to prevent property fraud from occurring. But Clerk Yarbrough has established this program to let you know if something is happening so you can immediately take action. It gives you notice. It sends you an email or gives you a phone call when somebody's recorded something against your property that's suspicious. So if you register for that program, we can get you that notice right away, and then you can seek out legal help to make sure that that's resolved. Yeah, it's www.cookcountyclerk, all one word, no caps, no spaces, cookcountyclerk.com. Okay. There was also a question as to, I'm sorry, Robin. So I was just asked to mention that we have the forms for TOTI here with us today. So if you want to fill those out, you can turn those in on site today. If you don't want to do that today, we do have forms available on that website that I gave you. So you can go onto our website, download the form, print it out, and get it filed that way. You can either bring it in or send it in. The fee for filing a TOTI is $50. So you can do it any way you prefer to do it, but if you're interested in a TOTI, that's how you go about it. Thank you, guys.
Here's another question. If I transfer my property to my daughter now, how will that impact my no tax status on my property? So let me ask you all, should this person be transferring their property to their children now? No. Okay, but even if you do, and you will lose your tax exemption status if you do that. So now you're not going to own the home, and your property taxes are going to go up, and just not a good idea to do. Please don't do that.
What happens if the executor of an estate passes? How is it then executed? Okay, so whenever we prepare wills and trusts, we always have a succession. So if the first named person is unable or unwilling to act, then it moves on to the next person. And I like to have as many permutations as you can think of. I mean, it seems it is so unlikely that it would go past the fourth person. But then it would go by statute. Who has preference in obtaining letters of office?
And what is that costing you all along? You're down to 1 executive, 2, 3. Wow. Somebody's going to have a good dinner that night. Some lawyer is. You want them just. Here's what the research suggests as well. It suggests that no matter what information you group of people receive today, only 10% of you are going to do anything about it. So still 90% of you are going to end up in the probate process. Because even after this information today, many of you are going to procrastinate, and you're just not going to get it done, and it's going to end up through the probate process. And then, sorry, it's going to cost you what it's going to cost you. But the clerk's office offered you the information today. We're trying to be as candid as we can with you about how to save your family money. But still, the research suggests that still only 10% of you are still going to get anything done about it. That's what keeps lawyers in business. So here's a good question here. And whoever wrote this, the handwriting is beautiful. Okay. The question is, would you suggest preparing a mock living trust with all assets and wishes before visiting an attorney? Well, yes, you do need to have a list of your assets because the attorney is going to need to know that. And a good attorney will help you walk through what you're trying to accomplish. So if you have some idea, that is going to be helpful. So the answer to both of those is yes and yes. You should have some sort of idea of what your assets are, and you should have some idea of what you're trying to accomplish.
Okay, how do you title a living trust as beneficiaries for retirement and life insurance? So when we prepare a living trust, we always give our clients what's called homework, and it's on a special piece of paper. We do it on a blue sheet of paper so that you know that this is very important. The only thing that gets when you sign a trust, so I'll walk you through our process. So we meet with you, we discuss what your estate planning goals are, what the best approach to be able to meet those goals. We get all of the information necessary to be able to prepare a living trust, how you want it passed amongst your loved ones, and then we prepare the documents. When you come back in to sign the documents, then that's when the trust gets created, okay, on that date. It's not immediately funded. What we do is we prepare a deed in trust, and that takes care of your property. So I'm gonna explain it like this. Say the living trust is a bowl, okay, and you are the initial holder of that bowl. So that day that you sign that trust, you're holding the bowl, but there's nothing in it, and so we take care of your house. We'll deed your property into the bowl, and so you know that will pass in per the terms of your trust. You are going to be responsible for changing either the beneficiary or the title of all of your other assets to you as trustee of your trust. And we give you specific instructions that say, this is how you want to change the title. Because if you don't change the title, it's going to end up, because it's going to have to go through probate to get into the trust. Okay?
You know, one of the things, too, that we see over and over again is many people have some estate planning that they've done over the years. And when they come into our office to review it, oftentimes we find they don't understand what they have, and then it's not even really what they want when we explain it to them, this is what you have. So if you have some estate planning, you may want to set up a consultation with a lawyer, go in, let them explain it to you what you have, because all lawyers are not created equally. And some of them don't take the time to explain it to you and make sure you understand and make sure that you're accomplishing what it is that you want to accomplish. So if you have some estate planning, especially if you have a will, you want to keep your assets from passing through the will. And so make sure that you have some sort of trust, living trust, land trust. There's variety depending on what you're trying to accomplish. And again, no matter how much the cost is on the front side creating the will, it's going to save your family time, stress, and money when you go to heaven. Here's another question. When you pay off your home, shouldn't you receive a deed to your property? I did not and have no idea how to obtain a deed. This is a common question, common misperception. The fact is, you receive a copy of your deed when you purchase the home. So at the closing, you get your deed then. Oftentimes, what people mean is, do they get some sort of notice that the home has been paid off? And yes, once the home is paid off, you do receive what's called a satisfaction of mortgage. And what typically happens is the mortgage company sends this document to the Recorder of Deeds office automatically. And then once it's recorded, then the Recorder of Deeds office sends you the recorded satisfaction of mortgage showing that there is no more money owed on the home. But most of you have copies of your deeds. But if you need a copy of your deed, you can go to the Cook County Recorder of Deeds website and you can print it for $5, $6 or whatever it may be. But it's not that you get a copy of the deed once the mortgage is paid off. You get a satisfaction of mortgage that shows that there's no more money owed on the property once it is paid off. You can get a deed anytime for your home, whether it's paid off or not.
Okay, I'm going to make this into two questions. Any attorney can do a trust? No. Only attorneys that practice in the area of estate planning should do a trust. And what are the steps to create a living trust? Well, I would start by making an appointment, making a consultation with an attorney who deals in estate planning. We don't charge for a consultation. You just find an attorney that you trust and meet with them and see if that person is going to be able to help you make your estate planning goals become a reality.
Now, there's two different processes because I do charge for consultations. And so we charge a consultation fee, and if you come in and if we do the work for you, we'll give you full credit for the consultation fee. For me, being a lawyer, consultation fees are some of the best fees that you can pay. Because, please forgive me, my position on consultation fees is if you don't pay a consultation fee, then the lawyer, they need to sell you. Because you can't come into a lawyer's office for an hour for free. So now it's not so much, in my opinion, please forgive me, it's more for the paid consultation fee, it's more about information. If you come into our office and I don't charge you for a consultation fee, I have to close you on a transaction then. So for me, do not shy away from a lawyer that's charging you a consultation fee because in my opinion, those people get the most best information. And then even if they don't decide to do business with you, then they'll go home and process it and say, okay, I understand that. If you come into my office, 45 minutes, no fee, then I'm gonna hard sell you on this, that, whatever it may be, because you know what, I gotta make a living, and so don't be so put off by some people. No fee. I have a fee, but for me, I find that those people get the most information when they pay the fees. Do not balk at consultation fees if someone charges you a consultation fee.
No, and I think that's a good approach, Ted, where you then you give them full credit for it if they choose then to have an estate plan with you.
Here's a question regarding TOD for bank accounts. Is adding a person's name to your bank account sufficient, or is a TOD still required? Well, again, this is why you guys came here today. You're getting good information. Should we be adding anyone's name to our bank accounts? No. Sometimes not even our spouses, right? Okay, no, please don't ask. I don't want to get anyone in trouble here. But certainly not the children. Okay, we just want to name them as beneficiaries or TODs on every single account. And I don't just say you have to have beneficiaries on them. They have to be current. Because we've seen cases on life insurances where people have, not long ago, we were into a lady, her husband passed away. He was at work one day, unexpectedly, 48 years old, passed away unexpectedly, had a $500,000 life insurance, had been married to the present wife for 8 years, never changed the first wife's name as a beneficiary. First wife got a $500,000 tax-free lump sum. Okay, so not only must you have beneficiaries, you must make sure that they are current and the people that you want them to be today.
Okay, if a will does not avoid probate, then what does? A trust, as long as you fund the trust.
Let's see. In case of all the, can they still sign or would you be considered not being of sound? Okay, in case of the, I'm not sure what this for, owner, family member, older family member in radiation chemo, can they still sign or would it be considered not being of sound mind? know what? So the issue with this, I'll paraphrase this question. The issue is, when is someone competent to sign the documents? This is actually an excellent question because we haven't touched on this today. Competency is a medical determination. It's not a legal determination. It's a medical one. And so, just because someone has Alzheimer's does not mean that they are incompetent. This question is relating to someone with cancer, chemotherapy, radiation. That does not mean that you are incompetent. I had a client in my office the other day, 99 years old, and her daughter was trying to tell her what to do, and she politely told her daughter, not so politely, by the way, please, I'm making these decisions. So competency is a medical question. Just because you have an illness does not mean you are incompetent. Just because you are aged 99 or even older does not make you incompetent. So. Well, dementia, that's stages of it. So everyone with dementia is not incompetent. So again, in dementia, that's another great issue. Dementia is really prevalent. Okay. And so if you see people with signs of dementia, you cannot wait until it gets to the point where they are incompetent. Another thing too, uh, um, some of you, this information is not just for you in this room. This information is for your friends, your families, your loved ones, especially for you ladies, because you ladies are caregivers and you're going to be making decisions for parents, grandparents, husbands, sometimes ex-husbands. I am so surprised that we get so many ladies that bring in their ex-husbands to do the estate planning, not for their benefit, but for the benefit of their children. They want to make sure that their children are going to get the assets without spending a whole lot of money. That surprises me to no end when I see exes come in caring for one another. That I really find that frankly lovely. Okay, so but competency is a medical determination. Just because one is old, illnesses. I did a hospital visit for a young lady maybe a month ago. On Thursday, she had breast cancer. On Thursday, did a complete estate planning for her. She passed away on Sunday. Okay, so almost even up until the end, as long as they are competent, they can still prepare the documents.
And I handed you that question just because that addressed the Alzheimer's. So I thought you.
My wife has Alzheimer's. Went to file a TODI naming my daughter. Our children's wife takes care of their mother. I have set up for their care, money for their care. Okay, problem. Well, my wife has all. I just want to. Oh, I want to file. Well, the issue is she still competent? Again, so it sounds like this question is the wife has Alzheimer's. Sounds like she has a home in her name or as partial owner, and they want to do a TODI or some sort of estate planning. Can they still do that if one of the parties has Alzheimer's? Well, it depends on the level of competency and the depth of the Alzheimer's. Potentially yes. Sometimes no.
And along those lines, can you change a joint tenancy deed and use a transfer on death instrument? So you can break the joint tenancy, but what would happen is you'd only be transferring one half ownership of that, unless both parties that were on the deed in joint tenancy chose to prepare this transfer on death instrument, and then otherwise the joint tenancy just stays. No tenancy changes based on you filing a transfer on death instrument. That does not become effective until the death of the second of the two to die.
Here's a question: when there's property, when there's a transfer of property, is there a tax on that, and what percentage is it? Well, when they're doing a transfer of property via a will or a trust or a TODI, there are no taxes on that transfer. I think estate planning taxes started, 13 million, 15, 16 million? Something like, I can see some of you people must be concerned about that. Because I see some of you people who are going to be passing along that kind of money. I can spot you. And so, but for others like me, no concerns. Unless I think it's about 15 million. Under 15 million, there are no taxes on transfers.
If you have a will, doesn't the will need to be filed downtown with probate court? Not until, wills don't get filed until after the passing of the testator, okay? Because that means you can change your will time during your life. Wills are revocable instruments, okay? So it does not get filed until after. Plus, you don't want everyone knowing what your plan is.
Okay, here's a question. What's the cost to set up a trust? Um, you know what? I never discuss fees. People are so private about their lives and what they pay for their services. I never ever discuss fees. It's always personal. Uh, all lawyers are different, and so just find a lawyer that you like, that you trust, that's going to be clear when you leave their office. Just make sure that you understand what just occurred, okay, and then discuss fees with them. Um, I think they wanted you to talk a little bit more about the pour over will.
Okay, the female attorney, that's me. All right, so a pour over will is something that we create, that we prepare alongside the living trust. And the pour over will is catches anything that you did not put into the trust. It literally pours it over into the trust. So there are certain instances where people forget to put assets into the trust. Or change the title to those assets to the name of the trust. And there are other instances where you couldn't have planned for an asset to be in the trust. Two examples of that are, one is if you receive an inheritance during your lifetime, but you don't get that actual asset yet and you pass away, you wouldn't have been able to put that asset into your trust because you didn't physically have it yet. Another instance is if you're killed in, say, a car accident, your estate may have a wrongful death claim, wrongful death cause of action, and there's no way you would have been able to put that settlement into the trust. And this way you can appoint who's going to act on behalf of your estate. The executor would then be acting. And so those are two benefits of having that pour over will. The additional thing is the pour over will can dispose of your personal property. If you have specific items that you want, say an heirloom or a ring or something like that, that you want to go to a specific person, that should all be in the will or on a list attached to the will, specified for your heirs or loved ones, so that there's no question about it as to how you wanted that to go.
Here's a question. This question seems to be a lawyer's dream question. So the question is, what can happen if no one probates the estate, or who's going to be responsible for the probate estate? And then they ask about lawyers' fees. I love to talk about lawyers' fees and retainer fees. Who's going to pay them, and can they be paid from the estate? Well, that's a good question because someone has to probate the estate. And so the issue is who's going to do it. If there's a will, presumably there's someone named in the will to do it. If there's no will, then anyone can then petition the court to be named the administrator. And then oftentimes there's more than one person petitioning the court to be the administrator because they think they're going to control the money. So what happens then is everyone hires a lawyer, then there's going to be some hearings, and the lawyer's going to be billing and amen. Okay, and then that's what will happen if there is no one named to manage the assets. Then there's going to be some hearings, and the court will ultimately determine it. Can fees be paid from the assets of the estate? Typically, for me, the answer is no. Typically, I want our fees, at least a portion of them, up front, because I don't want my fees to be caught up in your battling, because some of these matters can go on for literally years. And so perhaps a portion can be settled through the estate, but the upfront initial cost, which is for me, would typically be half of what the fees are going to be. And so again, this is all if you have to go through this expensive, stressful probate process. That's why we want to help you avoid it.
Follow up to this card here. What's the cost to maintain the trust? So there is no cost to maintain a living trust. That's a nice thing about the trust. And there's no, if for example, some people get what are called land trusts, and there's an ongoing annual fee to have your property in the land trust. And really, land trusts are not as common of an estate planning practice these days. Having the living trust is a more comprehensive way to help your loved ones to be able to distribute your estate upon your passing. I've had several cases recently that have dealt with land trusts, um, and the litigation that is part of that just is taxing on the family members. And then what should you fund a trust with? So all of your assets should either have the title to the asset should be changed to you as trustee of your trust, or the beneficiary should be changed to the trust. Now, if it's an asset that's held in joint tenancy between spouses, then, or I'm sorry, if you have an asset and you have a spouse, your spouse can be your primary beneficiary, but you should at least have the contingent beneficiary be the trust.
There are a couple questions online that might be helpful if we answered those for the group. If the two of you could answer this question, it would be very helpful. Can you repeat again why we need powers of attorney, why we prepare those documents?
Well, that's a great question. The good handwriting person just sent another question asking to clarify that. Well, you want power of attorneys because you need someone in a position to make health care and business decisions for you if you ever become incompetent. Whether you're having surgery, whether you have dementia, if you have someone named through the power of attorneys. Again, there are two of them, one for healthcare, one for business matters. Everyone needs them both, whether you are married or whether you are single, you need them. Because, again, if you don't have power of attorneys and then one becomes incompetent, then they aren't able to sign them. And then the only way your loved ones can get in a position to make decisions for you is to go through the probate process to be appointed their guardians. Very complicated, very expensive, very easy to avoid. You just have to have the power of attorneys before you need them. You cannot wait until it's too late and someone's not competent to have them. But what they do is, again, they allow you to name a primary person and a secondary person to be in position to make decisions for you only if you are unavailable to make them for yourselves. As long as you can make your own decisions, you will. Only in the event that you can't, you would have named the person of your choice to be able to do it. If you wait until someone has to go through the probate process to be appointed your guardian, you don't know which one of the kids are going to do it. Is it going to be the good one or the not so good one? Okay. Or, even worse, the public guardian's office. That's a whole nother story. So please get your power of attorneys for yourselves and your spouses so you can name one another to be in a position to make decisions for you if that's ever required. Yes, you need a lawyer because, again, we've seen them so often where people come in, and they have documents, they're prepared. Listen, people come in with documents on napkins and they think it's valid. And they come in with documents that are not signed, not witnessed, ill prepared, and they're invalid. And if you need them, they have to be right. And so it's worth the expense to have a lawyer to do them for you.
Yes, they have to be right, and the only way that you can ensure that they'll be right is hiring an attorney that you trust to do the job right. Okay, and how do you make an existing will null and void? You destroy it, but also if you get a new will, that revokes all prior wills. Okay, and then if do you give executors copies or originals of your will? When you get a will, there should only be one original. Otherwise, every original will would have to be presented to court and presumed to have been destroyed by the testator. So if you hire an estate planning attorney, you should only have one original of your will. As far as a copy to the executor, it depends on how much you want them. They should be aware of where the will is located in a safe spot so that in case they need to get it, then they can. But it's up to you whether or not you choose to provide your executor with a copy of the will, so that they know the breakdown. Because as I said before, you can change your will at any time during your lifetime.
Please forgive me. I have another attorney alert. When I was doing wills for my clients, I did one or of two things to make sure that the family came back to me to make sure I was the attorney that got the fees for the probate. Now, again, as you probably already realized, I'm not the favorite of lawyers, okay, because I'm giving some information. But one, I would write myself into the will. I would say, I, Attorney Ted London, will be the attorney that will probate this will. So when your loved ones or you went to heaven, you had to come back to my office. I'm in the will as much as the children. Or I would keep the original copy. And so when you or your loved one went to heaven, I have the original copy. So I did the will, I have the original copy. Why would I be the one to probate it? And again, fees. Well, then we have associates. We have associates. So these are just two of the insider tips that lawyers do. Sorry, lawyers. Hope not too many of you are listening. But they write themselves in the will, or they keep the originals. So either you're going to have to come back to them one way or the other so your family will have to come back to my office to get the original, and then I'm going to say, listen, let me probate this for you. And then why wouldn't you let me? I did the will, I have the original. It makes it so easy for you. And it's just you have to have the original. You have to have the original will to probate it. No, they're going to typically need the original will. Yeah. So whoever has the original, especially if it's in the lawyer's office, well, your family's going to have to go back to that lawyer, and then he just has a built-in client.
I don't keep the original.
Yep. Well, I did.
Yeah.
And
right.
I wrote myself in the wills. And I wrote, listen, excuse me, why wouldn't I? If I did the will, that means the family trusted me. That means presumably your loved one's going to trust me to manage it after the person goes to heaven. I'm just going to make it easy for everybody. So,
okay.
No, of course not. No, of course not. No. Just call and say, okay, London, they hired me to do this. And so, no harm, no foul. It's 1 out of 50.
Ted, I'm not sure if the people online can hear the question,
okay.
So it might help to repeat the question.
What was the question? I don't know. Well, I think the bigger question was, I think I wasn't responding to a question. I was just giving an insider's tip on how sometimes lawyers manage estates to assure that they get the second part of the estate planning or the probate. Because again, it's relatively inexpensive to do a will. The money that attorneys earn essentially comes from the probate side of it. And so if you can assure that you're going to get that part of it, as opposed to just the small amount to do the will, then that's really where the money is earned.
Okay, this question says, if I had a will done when my child was a minor, it had a provision for a testamentary trust to be set up under the will for that minor. Child's no longer a minor. What needs to be done? What I would say is anytime you have a life-changing event, that would be a good time to consult an estate planning attorney and just have a check-in and make sure that your estate plan is still meeting your goals, because those evolve over time, right? And so what your needs were back then may not be what your needs are now. And so maybe it's time to change focus and to redraft those documents.
And that's another great point. You should probably be reviewing your estate planning documents every 5 to 7 years or so, just to refresh your recollection about what you did. Do you need to add something to your trust or your estate planning? Did you buy more properties? Do you have more grandchildren? People love their grandchildren. And so oftentimes when we're doing estate planning for people, it's not just for the benefit of the children, it's oftentimes for the benefit of the grandchildren. And so And so again, you want to make sure that there are none left out. And so you may want to just review it every 5 to 7 years. I think that's reasonable. A couple more questions. Let's see. Do you recommend a toady instrument for the transfer of property or instructions in a trust? Do you file the toady instrument before death? You have to file the toady instrument before death. Yes, or otherwise it's not going to be valid. And again, for me personally, again, there's different types of lawyers. There's 1,000 different lawyers, and everyone has a different way to manage things for you. My way is I like simple. I like things because my average client's about 80 years old. And so you have to explain things to 80-year-old folks in a way that they understand. Now, oftentimes they'll tell me, you know what, I'm not going to remember all this tomorrow, but I understand it now. And that's good enough for me. Okay, so you have to make sure that you're with someone that's going to explain things to you in a way that you understand and that you feel comfortable with. It's going to really help you accomplish really what you're trying to accomplish. That's our goals, and our objective is to help you accomplish whatever it is that you want to accomplish, which is typically get the real estate to someone and get the money to someone, and seamlessly without them having to pay a lot of money to acquire it.
There's a question here online from Irma. My father passed and his insurance policy didn't have a contingent owner, so it was switched over to the estate of. Is it true that I have to open an estate without a will? So if one thing that we didn't touch on is if your estate is less than $100,000 in assets in your name alone, then you may be able to get by with what's called a small estate affidavit. Ultimately, it's going to be whatever that insurance company is going to require or that financial institution. So I've had banks where they still require letters of office, even though the small estate affidavit should be a sufficient replacement for letters of office. So letters of office are, it's a document that you get when you file a probate matter. And it's issued to the administrator of the estate. It is basically like your license to be able to deal in the probate estate. A small estate affidavit has similar authority, but some banks the banks get to call the shots. So an insurance company is going to require what they're going to require. And if they require letters of office and are only going to issue a check in the name of the estate, for example, then if your bank will only deposit that if you have letters of office, then that's what's going to rule the day.
You know what, man, add this. A lot of times those bankers, they do not have a clue of what they're talking about. They are given so much misinformation at those banks when someone passes away. And it is statutory that if it's under $100,000, you can use a small estate affidavit for a life insurance policy for any bank accounts that's under $100,000. But those bankers are telling people even nominal amounts of money in their accounts, $25,000, $50,000, $15,000. Well, you need to open up an estate. You don't. So again, it's worth having an attorney that you can have a relationship with, where you can make a phone call and say, is it true that I need the bank told me I need open up an estate for $25,000? You absolutely do not. Okay, and so sometimes you do have to bully these banks because they will try to tell you that you need it and you don't. And so you have to do a little bit of lawyer bullying. And then within a matter of a day or so, it is all resolved, typically. But again, you know what? Well, here's what we didn't talk about. We didn't talk a whole lot about the whole probate process. And let's talk about the probate process. This is for you, 90% of you, who are not going to do any of this. This is what your loved ones are going to have to go through. You're going to have to hire a lawyer, and then you have to file a petition, and someone has to be named the administrator, and then you're going to get someone's going to be appointed as the administrator of the estate. And then they're going to be able to collect all of the money and the assets, sell the real estate or whatever it may be. Then all those funds are going to have to go into an estate account. And then they're going to have to stay in that account for at least 6 months because there's what's called a creditor claim period. And if your creditors make a claim, hospitals, credit cards, physicians, here's a big one, student loans, they get an opportunity to collect what you owe them. But If you keep your things out of the probate process, the creditors don't have an opportunity to make a claim, and you don't have to pay them. Hospitals, physicians, student loans, credit cards, whatever creditor it may be, if you avoid the probate process, you avoid the creditor claim period. That's the reason itself to avoid the probate process. Well, their function is to collect all of the assets, home, bank accounts, secure them, putting them into an account, in a state account, paying any creditors that make a claim, submitting all the proper documentation to the court, and then ultimately paying out the heirs and the lawyer, and then ultimately closing the estates. So it's a process. Typically, the court gives about 18 months open and close an estate. Oftentimes, it goes much longer than that, and if families are fighting, even longer. So, but a reason in itself to avoid the probate process means not having a will is you avoid the creditor claim period. You don't have to pay doctors, healthcare providers, student loans, credit card debt, any of that debt that is not yours but belongs to the person that passed away that transfers to their estate. If you don't go through the probate process, there's no access for them to make a claim to collect the money. And all the dollars that they collect, that's money that's taken away from your loved ones that could have otherwise gone to them. I think the gentleman has a question. Well, if there's no money.
Do you want to repeat that?
Well, his question is, if the state doesn't have any liquidity, then the creditors can't make a claim. Let me rephrase his question. If the state doesn't have any liquidity, he's not going to be able to find a lawyer. But there's no money. So you would never open up an estate if there's no assets in it. There's no real estate, no money. There's nothing. Well, no, because they can still collect from the value of the real estate. So yes, if there's equity in the home, yes, the creditors would have a right to make a claim if the home had to go through the probate process. Yes, they would have a right to make a claim.
Without the probate process, there is a 2-year claims period. The one advantage of having the probate process is that you shorten that claims period to a period of 6 months. But you're going to be spending a lot of money on attorney fees, and so your best bet is to have the investment in a good estate plan, and to help your family navigate the difficult time after you pass. Yeah, the best plan is to have a good estate plan, and that will allow your family to navigate the difficult time after you pass, right? And so to be able to spend time focusing on the death of a loved one as opposed to what their loved one's wishes were.
And the best way to really prepare a good estate plan is really to have good, solid, straightforward information. That's what people need. You need good information. When people have good information, they make good decisions. So oftentimes people get so much misinformation and they're so confused, and it creates a real mess. That's why I'm a proponent of an attorney that charges a consultation fee, because they're just going to give you, typically, they're going to give you straightforward information, and then you can process it and make your own decisions without someone really selling you a trust, this, that, whatever it may be, and you can decide on your own.
The question was the benefits of a transfer on death instrument rather than a trust.
Well, what?
Well, I want to touch on what this gentleman was talking about, when the only asset of the estate is the real estate. You know, with someone that doesn't have money to be able to invest in a good estate plan, a transfer on death instrument will allow your family to be able to take ownership of your property after your passing and avoid having to go to probate. And so it is it's a great backup plan, right? And it's a great tool that if that's all you can afford, that will allow your family to avoid probate. I volunteer with an organization called Chicago Volunteer Legal Services, and most of the probate matters that come into them are families that don't have the funds to be able to pay for an attorney, but that have real estate, and so there's no liquid assets in the, and by liquid I mean monetary, bank accounts or things like that. There's no money to be able to pay an attorney, but they want to be able to transfer ownership of the real estate to them, and you can help your family to avoid that by preparing and recording a transfer on death instrument.
Again, a transfer death instrument is a very valuable instrument for some families because not all families need the same level of sophistication of estate planning as others. Again, but if you just have a home and it's paid for and that's really the only asset that you have, yes, a toady is going to be all you're probably going to need to transfer the home out of your name once you pass away to all the children or which one? The good one. Okay, that's your choice, and they're going to be able to do it very easily without a lot of cost. But again, you have to do these things while you're living. They have to be prepared and recorded before you pass away. And again, I'm just going to harp on this one more time because I'm really want to get on someone's nerves here. I'm sure I have done that already. But just one last thing is, again, only 10% of you are going to do any of this. That's what the research says. And so don't be that 10% where when you go to heaven, then your loved one's going to have to go through the probate process because you just procrastinated, you didn't get around to it, you knew you should have, and then now your loved ones have to see the lawyer and go through all the process that we talked about this afternoon.
Before we go, I was asked to elaborate on the various divisions of the Cook County Clerk's Office and what they do. I'm not sure that was clear from the video, so let me try and give you an overview of the clerk's functions. The clerk maintains a vital records division, which is the keeper of the records with the birth certificates, death certificates, marriage licenses, all of the vital records that we use in the daily lives of people are kept by the Vital Records Division. When you need a copy of one of those documents, you can go seek a copy of that document from the Vital Records Division. We have an elections division. Clerk Yarborough is the chief election officer for Cook County. Cook County encompasses the city of Chicago, but city of Chicago has its own elections division. So our elections division handles the elections for suburban Cook County and all the countywide elections. We have a property tax division, real estate tax services division that handles several different functions. This is the place where you go to redeem delinquent taxes. So if you fail to pay your county property taxes and you need to redeem those taxes, you would come to the county clerk's property tax division to redeem your delinquent taxes. In addition, that division calculates the tax rate for all of our taxpayers. We're not the one that sends you your bills. We're not the treasurer's office. We're not the assessor's office. We're not the one that determines what the assessment of your property is for tax purposes. But our property tax division calculates what your tax rate will be. Your property is part of several different taxing districts. So you have a library district, you have a school district, you have a police and fire service that are all being funded through your property taxes. All of those things go into a calculation, and the county clerk has a division that sets that calculation, does the calculation to figure out what your rate is going to be. We also have a recording operations division. Our recording operations division is the keeper of records for all chain of title records on property, on land records. So if you're looking to determine who owned a property in the past, you can research that type of thing. The chain of title is something that's kept by the Recording Operations Division of the Cook County Clerk's Office. As part of our ethics division, we also are the keeper of the records for disclosures of economic interest. So when candidates run for office, they're required to disclose what their assets are. And those disclosures are kept by the ethics filings unit of the elections division in the county clerk's office. I'm not the most versed in it, but we have a representative with us today from our Veterans Services Department. We have a Veterans Services Department that records the DD-214s for veterans. So people that have been discharged can make a permanent record of their service to our country by recording their DD-214. We also offer a discount card for veterans. So if you're a veteran that served in our armed services, you can register with our office to get a discount card that offers discounts on many different services. I can't really give you a litany of those services, but we have a representative that might be able to tell you a little bit more about those things.
Thank you, Scott. Do I have any veterans here today? Please tell your family then. We offer the military veteran discount card, and we also strongly encourage our veterans to record their DD-214, which, as Scott so aptly described, is the discharge paper that you receive upon honorable discharge of serving our country. We have about 150 different businesses. We're going to be introducing or reintroducing a new program with the Chicago White Sox for veterans, where they can go to they're offering 33 games. So please tell your veteran friends. And for anybody who's on Zoom with us today, if you're looking for a discount card or any information on our veterans office, to go to cookcountyclerk.com, and there's a veterans tab. The cookcountyclerks.com will be on a lot of your literature. So thank you very much, and thank you very much for the opportunity, Scott. I greatly appreciate it. And Mr. Reintroduce.
Let me just mention the two final things that the clerk's office does. I've already mentioned the property fraud alert system where you can register for those alerts. We also have investigators, property fraud investigators, that will coordinate the gathering of documents and the referral of a matter to the state's attorney's office if, in fact, there is a problem on your chain of title. If somebody is trying to take advantage of your property, we have property fraud investigators that will help get law enforcement involved. So those are the things that the clerk's office does, and I appreciate your time listening today. Notary department. I don't. Robin, do you want to?
You have to apply with the state of Illinois to be an Illinois notary. So there's a form you fill out, you complete it, you get a notary bond. That's sent down to the state of Illinois. They do an investigation on it, and then they do the certification and send you your certificate to be a notary. And I think you pick up that notary certificate in our office and pay a small fee. Okay. All right. So there's something that I didn't hear in the presentation that was addressed by our attorneys. So when you fill out the transfer on death instrument, it's filled out in its entirety. It's brought down to the Cook County Clerk's office to be recorded. When we record it, it goes on your chain of title. So that if in the event that you die, everybody wants to live forever, you can direct your loved ones to come down, bring a copy of your death certificate, and you can have that property transferred over into your name. The fee that we charge at the Cook County Clerk's office is just $50. That's why this program is so important to us, because a lot of us in our low-income communities, or not even in the low-income communities, cannot afford an estate plan, an elaborate estate plan, or to have a trust in place. And this transfer on death instrument allows you to transfer your most valuable piece of asset over to your loved ones without having to go through probate, without having to have extensive attorney fees. So that's why we bring this program out to the community to let you know that you have estate planning alternatives. Okay? So this is an alternative. We're not saying you have to do this, but it's something that offers you an alternative to an elaborate estate plan. Okay? So all of this is just information we're bringing out to you to educate you about what's out here for you at low cost or free. So the property fraud alert is something that you can apply for that helps you protect your property to keep it from being stolen. Just like you check your credit, you should check your property records, okay, to make sure your name is on that chain of title. And when you go to check your chain of title, you look for the last recorded deed on your chain of title. And if your name is not on that last recorded deed, you need to contact our office and talk to one of our property fraud investigators so that they can help you through the process to find out what's going on and give you direction on what can be done so that you can get those records off, that name off of your property record, okay? Because these things are very, very important because people are losing their properties. People are putting their names on the chain of title on your deed or recording false deeds, and they can take out a mortgage on your property. You know that? And you end up, they get the money, and you end up paying the bill. It is crazy. And in our presentation, we addressed it because it's called deed fraud and paper terrorism. So you've watched the news and you've seen on the news how people have found squatters in their properties and they can't get rid of them. They got to go to the court system. Or somebody puts their name on your deed. They take ownership, change your locks. Police can't do anything if you call them. You have to go through a court process. So you need to take preventive measures to protect your property because that's what you put your hard-earned money in, right? So this is good information. It's left up to, we bring it to you and it's left up to you to use it. Now the property fraud alert forms, you have been given those so that you can fill those forms out today. You complete them. You don't have to have your PIN number because we can look it up. You sign it, you date it, you show us your ID so that you can prove that you're who you say you are. And we take those forms back to our office and record them in our office so that that goes on your chain of title. Now, even if somebody takes out a lien on your property or you take out another mortgage on your property, you will get an alert, okay? So please, please, please take advantage of the free information that we're giving you because we're very passionate about bringing this to you because people perish for what? Lack of knowledge. So we're trying to give as much information to you that you can use. Now we have a couple of other events coming up, but I want to thank our attorney fielding the questions. So give them a hand. I want to thank our office for being here to assist us with legal questions. We want to thank translator Dan for being here because he would assist some people that have been here. Now, we have other events that are coming up. If anybody in here has an organization that would like to put on one of these events in their community, my name is Robin Staggers. I am I tell people I'm a gopher, but I am the community affairs person for the Cook County Clerk's office, and I help set up these forums in the community so we can bring this vital information to you. Now, how many of you learned something today? So it makes it worth our while to come out and share it with you. And you can attend as many of these sessions as you want. So if you didn't get the information you think you needed today, we have 2 events coming up, one on April 12th, and that's going to be where? Glenwood Linwood Library. Okay? You can go on our website, register for that event. If you'd like to come, you're more than welcome. There's no limit to the number of events that you can attend. Then we have another one on April 19th, and that's going to be in Victory Christian Center in Park Forest. So you can come to that event. If you can't come to any of those, we have a number of events that we're planning. You can go on our website and find out where they're going to be, and you can register through the QR code. You can attend. If they're hybrid, you can attend in person or via Zoom. If it's in person, come on out. Okay? All right. We have any additional questions before we close out? First of all, okay, I'm sorry. Okay. Legal aid. And our other partner's not here. Legal Aid Chicago. Legal Aid Chicago provides legal services for low-income residents or in low-income communities. So, yeah, they provide presentations as well. And we also partner with the Center for Disabilities and Elder Law. So you can also contact them for assistance if you need to. I don't have their information or their phone numbers, but you can get it online. Okay? So the Center for Disabilities and Elder Law and Legal Aid Chicago. Legal Aid, AID, Chicago. And if you need to contact me, my name again is Robin Staggers. And my number is 312-603-3974. Yes. And our Zoom, thank you to our online attorney, Kane Trent, and our online audience. This recording will be posted online soon. So if you need to refer to this presentation or this forum, you can view it online via Facebook and YouTube. Okay? I'm sorry. Huh? Oh, it's our pleasure to be here. And thank you for the 10th Ward and the CPS CPD for having us out. You guys have a good afternoon.